He's quite infamous about town. Alan is the deputy county administrator, and he's the sort of serves as the CFO of the county government. Everything fiscal in nature, in addition to being my right-hand man on everything county government. By the way, after we talk today about charter county government, do an overview at your next meeting, we're going to go into county government, Leon County as well, just to give you a more thorough idea of what we do at Leon County. So you'll be hearing more about this sort of thing. And I'll bet you, as long as you've been around in the community, you'll learn just a few things that you didn't know before that we do in Leon County government with the 50 or so different services that we provide and that sort of thing. But Alan has extensive background in county government, almost 30 years now. He's a lot older than he looks, and he hails from two other charter county governments where he had similar roles and in both Sarasota County and Pinellas County, but he's now been here 18 years. Oh my gosh, I can't believe it. And you got LaShawn Riggins over there, and Herb, I'll let you more formally introduce LaShawn. Why don't I let you do that now?
LaShawn is going to be my backup. LaShawn is the deputy county attorney, and like Alan, will be the fill-in for me when I'm not able to be here, which includes next Thursday. And so either of the two of us will be at all of the meetings, and mostly both of us. And LaShawn has been with us 7 years. She also does not look her age, but 7 years in the county attorney's office puts about 40 years on your face. And we recruited her away from Okaloosa County, where she was a prosecutor with the state attorney's office there. And prior to that time, she served a lengthy stint in the Navy. So she has all that sort of organizational background coming in. And from my perspective, this will be my 39th year as a local government attorney. 27 here, 10 in Delray Beach before that time. And it's, yeah.
It shows.
It shows, but it also shows that it is one of the more fascinating and fun things to do as a lawyer. And that's why we're all excited about doing this, because it gives us two opportunities. One, to hear new things from you, and the other is to re-examine the roles that we play for the county and the county commission. So we're looking forward to it.
Absolutely, absolutely. Let me just finish around the room here real quick. We got Rebecca Voss here, works for the clerk of the court's office. Rebecca takes the official minutes and that sort of thing, but Rebecca, she's great. I wanted to introduce you to her. Make sure you always say hello to her. You couldn't find a nicer person back there. Except if, of course, we're talking about Nikki Payton back there. Nikki is also another policy analyst who'll be helping out with us. She works here at the county, and she does exceptional work for us. So with that, that's just a quick introduction of who we are. There'll be a test on the names and titles and responsibilities, what they all do. But with that, I would just like to ask that you all introduce yourself to one another, and then we'll jump right into it and get the ball rolling. And so just maybe your name, a little bit about your background, your most embarrassing moment, whatever you'd like to share with the group. So Lee, we'll start with you.
I need my microphone. I'm Lee Hinkle. I'm retired, very happily retired. I came to Leon County in 1967 to go to FSU and never left. I've been here a long time. I retired from FSU and love the community. Happy to serve.
I'm Ken Hart. I practice law here in Tallahassee and for some period of time. I started here in college at 64, so it's been a long time. Spent a couple of years in Miami pretending to be a CPA for a while, but then came back to law school and been practicing law here ever since.
I'm Annis Prosser, been in Leon County for 45 years, been married for 45 years, so married a Tallahassee boy and went to FSU. I am also retired, recently retired and loving it. And my background is human resources, and I was a chief administrative officer for a local credit union and continue to do consulting for them.
I'm Casey Perkins. I've been a resident of Leon County my whole life, which is 32 years. I currently work for the Florida Association of Counties, but I've only been there 6 months, so I'm by no means an expert in local government. Before that, I was in the Governor's Office of Policy and Budget for 6 years. But this is my first appointment to any kind of public board, or commission, committee, so I'm really looking forward to it.
Good morning. I'm Gordon Thames. I run a company in town called Arbor Properties. We build and develop apartment communities. I moved here, I guess, around 1988, and someone like the rest of y'all have stayed. And I guess I'm not retired. I'm actually, Vince knows me well because I'm a customer and a frequent interactor with the county, so hopefully some of the perspective we bring is that of someone who's having to go through the process. Our most recent project, any of y'all go to Costco, is called Arbor Crossing at Buck Lake. It's right there at the corner of Mahan and US 90 Buck Lake Road there. So, going through all this required, some days a couple of the gray hairs on Vince's head may have come from me, but anyway, hopefully we can contribute.
Good. I'm Mike Urich. I am the Director of Strategic Initiatives for Big Bend Hospice. To explain what that is would probably take longer than this meeting allocation of time. I am finally a full-time resident of Leon County for 9 years. Spent a lot of time here in the past and always wanted to come up here and live permanently, so about 9 years ago I made it. Happy to be here. Thank you.
Thank you.
Good morning. I'm Reggie Ellis, Associate Professor of History at Florida A&M University. I first came to Tallahassee in 1999. I'm a two-time graduate of FAMU, went to the University of Memphis, and came back in 2008 and was on a full-time line in 2011. And in about 35 years, I'll be retired as well.
Hard to top that. I'm Neil Fleckenstein. I worked for Tall Timbers Research Station and Land Conservancy for 16 years. I coordinate land use planning and advocacy and now oversee our outreach and education program. And I work with 6 counties, but far and away, my heart is in Leon County. I live in Midtown and will do anything I can to improve the state of our community. Happy to be here.
I'm Catherine Jones.
Some of these mics need,
Yep, there we go.
Are automatic, but
yeah. I don't have an automatic mic. Catherine Jones, I came here in 1989 to go to Florida State and left to go to University of South Florida for graduate school, but came back here to raise my family. I work for Commissioner Nick Maddox, although for the record, he did not appoint me to the Charter Review Committee. So, love living here in Tallahassee, Leon County, and very happy to serve on this committee.
All right, she won't tell you, but you'll get to know more about your fellow appointees, but I just have to do it to her. Not only is she the commission aide for Commissioner Maddox, she also traveled around the world with the Peace Corps, which is really cool, and she was a warden in a prison. Okay, we'll discuss among yourselves later, and we'll come back to that, but just had to do that to her.
Good morning, everybody. My name is Ted Thomas. I came here in 1977, was transferred from Washington, D.C. with U.S. Forest Service. I served as Assistant Forest Supervisor for National Forest in Florida for 11 years. I took an early retirement after 25 years. Was around the house for 5 days. My wife told me to go back to work. I did that. I've been selling residential real estate since about 1988. It's great to be here. Thank you.
All right. Well, Heather, tell us who else we have in the committee now. When they come, we'll make their introductions even more painful since they missed the first meeting. But tell us who else is going to join us.
Sure. So also on the committee, we have Shane Hopkins, who is a local firefighter for Tallahassee Fire Department. We have Jay Revel with the Chamber. We have, let's see,
Kim Williams.
Kim Williams, and we also have William Graham.
Okay.
Who's a local attorney here.
Great, great. Well, today, as I mentioned, this is an orientation day, so So if you've got any great ideas, just keep your powder dry for a short period of time. We'll get through the basics, and then we're going to, like I said, we'll transition to this group. We think this part's real important. So I'm going to talk a little bit about charter county government. As I mentioned to you, I've taught for many years and done this stuff, but thankfully, I'm going to give you the abridged version of all this, because I think you're going to even have a richer learning experience about charter county government just by doing it, by rolling your sleeves up and really getting in there. So I'm going to hit the high points, but anything I talk about in my presentation, feel free. Actually, from a process standpoint, why don't you write a note somewhere once I get started? We'll come back to it and have a full conversation and go anywhere you all want to go on anything that I hit in this presentation. You're also then hear from, once we do that in terms of the broad overview, you're then going to hear from Herb Thiele, again, who's going to talk to you about Florida sunshine laws and some open government guidelines. We'll also go over your committee bylaws. Again, very much your committee, but we've started you off with some bylaws that have been approved by the board. Heather will explain those to you. Those are just intended to, again, just help you through the process. And finally, we'll talk about your committee schedule here. And then with that, let me just stand, go over to the PowerPoint here. And Heather, I don't know do you have the controls? Are you going to drive? All right, well you can drive then. Let me just get to my page here. So what I'm going to talk about, folks, again, we're going to hit the very, very high points. And I'm going to start off with just the very basics. What is a county charter? I'm going to give you a little bit of a historical overview of county charters and charter government in Florida. I'm going to give you a brief overview of Leon County's charter and how we got here. And again, at your next meeting, we're going to talk a little bit more about Leon County specifically. And then, as I said, you'll be off and running. Again, the people who are not here, they're going to have a much longer, more torturous presentation than you guys. So you're welcome. With that, we'll get rolling. Again, folks, what is a county charter? You'll hear us refer to this a lot as a local home rule constitution, and that's just what it is. A county charter is a living document which, as it says there, is intended to reflect the preferences of the local electorate as to the power, structure, and authority of county government. So pretty high level, and only the voters in Leon County can approve or amend a county charter. Next slide. So why county charter government? And we'll talk a little bit more about this, but essentially it reflects the fact that one size fits all government doesn't work for a state as diverse as Florida. It also reflects the fact that citizen determination should be reflected in the county government. It provides that we must do the same state-mandated things and carry out the same state-mandated responsibilities as any government or any county government in Florida, but it gives us more flexibility to both address state mandates as well as local issues and local concerns. And the big difference, and we'll go into a little bit of the history and background and a little bit of it, but the big difference is, unlike city governments, which are all charter governments, they are very bottom up. A group of citizens get together and decide how they want to structure their government, and how they want to pay for services, and what they want their city commission to look like, and that sort of thing. County governments are much different in that county governments their origin, I should say, is very different. County governments are political subdivisions of the state of Florida. And again, they were originally, Kim, you can sit right here. Have a seat. Hey, go, please. How you doing? We're going to make you sing here in a minute. So again, Kim, this won't take you long to catch right up. But again, county governments are very different in that they are what we call political subdivisions of the state of Florida. And you'll see here in a moment in a map that in the original state of Florida, and there it is, it's just geographically separated to originally carry out state functions, really skeletal state functions in what was a sparsely populated, agricultural, rural, mosquito-infested state of Florida, right? And again, so they're very different. So originally, the original counties were set up to carry out state responsibilities. And you all can see that even reflected today because we obviously provide for the sheriff, for law enforcement. This is a way that when Florida was organized, you didn't have to have one state prison, right? You got to carry out these skeletal state functions across the state of Florida. Could you back up just 1 minute there? Thank you. And I'll go into this in a little bit more detail. Obviously, a lot changed from since statehood to where we are today. And I'll back up a little bit, but essentially, the idea of a charter and home rule really emanated from the fact that, unlike cities who were always charters from the day they were born, counties' governments evolved into their local government roles from that political subdivision of the state role into very much like cities in carrying out state function, local government functions, that is. Quick view, you can see here that of the 67 counties, 20 of them are currently charter counties, but these 20 represent 75% of the state's population. So the quick math would tell you that once you get to be about 200,000 more, maybe 150, there's some smaller, almost all the bigs, that you start to become a charter county. And the reason that is, and if you just think about it from all of your own experiences, that's because those counties, once they get to that level, they really start to become local governments in their own rights and much less, again, political subdivisions of the state of Florida. But if you go through some counties and you ask yourself, why is everyone, Vince, not a charter county? Well, you all know you don't have to drive too far from Leon County to get into a county and you say, well, this probably isn't much different than it was in 1850. You know what I mean? Again, and that one size fits all just sort of reflects that. I'll get into why that happened in just a little while. But the most recent charter is actually our neighbor, Wakulla County, who's a very small county to become a charter county. But you may know their county administrator back then when they became a charter county used to work here. And when they imported him over there, he said, hey, I got a good idea. Why don't we do that? And so they're the most recent. And Manatee County is actually working on one now. So they got a group of folks like you convened, and they're working on doing that. They would become the 21st if that appears and is passed on the next year or the 18 election. Next slide there. So again, you sort of get a sense there from this map. And you see Mosquito County there. That's real. That existed. I think that's where Kim Williams is from. But you can see there that that again, this was a after 1 year after statehood there, that this was just really a very rural, sparsely populated, agricultural state of Florida. And then round about what does it say, 1936 there, obviously you can see that represents all 67 counties. And my point of showing this is to demonstrate really that in that period of time, in that window there, and again, I won't take a deep dive in there, but the original state constitution, what is referred to as the original state constitution, the 1868 Florida Constitution was established. And but between 1868 and 1968, a tremendous amount had changed. Probably most importantly, air conditioning, right? And what happened was the structure of the function of counties changed dramatically. And however, the structure of government stayed the same in that you still had counties defined in their roles and organization and responsibility directly from this 1868 Florida Constitution. So if you go one more slide there, Heather, what you see here is in order to appreciate what we refer to as home rule, you you have to understand what predated home rule, and that's called Dillon's rule. And again, just very quickly, it's just really more fun than anything else. But our friend John F. Dillon there was a Iowa Supreme Court justice, and in the 1800s, he issued a famous opinion. And again, we were still very early in the experiment, and his position was that local governments really shouldn't have very many powers and authority. All of their power and authority should emanate directly from the state constitutions. And in his famous ruling there, he said, they are, so to phrase it, the mere tenants at the will of the legislature. This guy could be elected in Florida today, couldn't he? You know what I mean? So again, that was John Dillon in the 1800s. But if you fast forward to about 100 years later, round about the early 1900s, 1930s and 40s, states started moving away from Dillon's rule. And you also have to appreciate it didn't start even much longer after Dillon's rule, because we were still in a country really that sort of detested large centralized governments, right, given our background as a country. So again, the states drifted away from that and more toward this ideal of government closest to the people and that sort of thing. And again, the Florida legislature around about in the 1960s, they had a little bit of a quandary on their hands, because now it was a much different Florida, and your 67 counties were doing much different things. And they had evolved beyond political subdivisions of the state, and again, into full-service local governments, really for the most part indistinguishable in many places from cities. But again, they were governed by this old 1868 Florida Constitution. And really, under Dillon's rule, because there was no home rule, they were presumed powerless to act without explicit authority granted in that 1868 Constitution. So if you wanted to do anything, even in the 1960s, you had to go to the state legislature and what? Get a special bill passed, right? And if you wanted to put up a traffic signal or open a library or start any type of program, it required you to go to the Florida legislature. And you can see there that in 1965, there were 2,100 local bills established, and in 2016, there were only 35 local bills passed. Again, understanding that in 1968, two very important things happened. One, we were constitutionally vested through that 1968, 100 years after 1868, constitutionally vested with home rule, and home rule there being that it says municipalities, generically, counties, cities, have all powers of self-government except those that are specifically prohibited or preempted by the state. Big difference, right, than explicitly provided by the state. So where you were silent, where the Constitution was silent, you were presumed powerful and not powerless to enact local law. So a very big difference. Again, 1868, two things. Home rule for local governments, constitutionally vested through that 1868 Constitution, and the ability to allow counties to establish a local charter. So why did they do that? Again, this was a great one for the Florida legislature at that time, because they said to themselves, wow, we've got two choices on our hands. We can either engage in comprehensive local government reform, because again, the form really isn't following function, or vice versa anymore. We're operating off this old 1868 Constitution. Or we can punt, and we can allow any county to do it themselves, to engage in comprehensive local government reform, to use a term, on their own through the establishment of a charter that their citizens can approve and amend over the years to reflect their preferences. Again, and they said to themselves, even back in 1968, you know what? Holmes County might not need it, but Dade County might, and Escambia might want it, but Leon might not. So again, they did it that way, and as I mentioned to you, 20 to date, but about 75% of the state's population. What else do we have, Heather? So this gets you into, with that as just a little bit of a background, when did we become a county charter? And we did it in 2002, which is fairly recently. I talked to you about Herb and I being around then through that process. And so we adopted what most counties start off adopting, which is what they call a starter charter or a simple charter. And I would submit to you that our charter still very much looks like a starter charter or a simple charter, but you know, so do those that have been around for 20 years. They still kind of have those basic tenets. And we've provided a lot of background material for you all in your books, and you can kind of compare other county charters to each other and that sort of thing with some of the unique elements that they have. But they all establish and define the roles and responsibilities of the county, of the constitutional officers, of the county's relationship with its municipalities, how they're governed, what does their governing body look like. And we have what we call a council manager form of government, which I know most of you get, but essentially that is, we don't have a strong mayor, we don't have a weak mayor, we have a council manager form of government, which most counties do, which most cities do, but obviously some don't, which basically has the county administrator as the executive and CEO appointed by the Board of County Commissioners who sets legislative policy, and there's that separation there. And it's really something, and I could talk much more about that, but anyway, so it also provides for a charter amendment process, importantly. But Heather, if you'd stay on this one just a minute, as I mentioned to you all, just to pause for a second, the county charter is provided in your materials. I'd recommend that you all take a look at it. You'll find that it really is an easy read. There's not a lot in there that's superfluous. Every provision in there really means something, and you might be interested in any of those sections, and we can extract those and talk about each of those sections. Again, wherever you want to go as a committee, Herb and I can discuss any one of those sections, and you might say, what does transfer of powers mean, or what does municipal powers mean? And we could talk about any of those. One of the things that we did, and again, there's not a lot that differentiates our county charter because, again, it hasn't been amended since it was put in place in 2002. But a couple of the things that you'll see in there, I'm sorry, I shouldn't say it hasn't been amended. It hasn't been amended through a charter petition process or by the Board of County Commissioners, but the last 2009 process advanced some charter amendments that I'll talk about. But Heather, can you go back just one more second? Couple of things that you'll notice that are distinct about ours, for example, in relationship to our municipalities. The way it works under non-charter, with non-charter counties is that your relationship between the cities and the counties are pretty basic. To the extent that that ordinances conflict, the city ordinances are in effect inside the city limits and the county ordinances are in effect inside the county. However, through a county charter, the citizens can determine through the charter, again, which ordinances prevail in certain circumstances. So a group of people might say, for example, as we did in the last revisions of the charter in 2009, which I'll talk about in a moment, we said that, you know what, doesn't make much sense to have conflicting ordinances with respect to environmental management. You know, environment doesn't know political boundaries, as we say, and so why would we have different environmental ordinances in the city and the county on what trees Gordon has to, you know, keep on his property and which ones he has to protect and that sort of thing. So we established in the charter, and you'll see there what we call minimum environmental standards, which meant to the extent that they conflict, the city's ordinance have to meet the minimum standard in the environment established by the county. Again, and it was the idea there was to provide some continuity, some simplicity, and that sort of thing on issues that, again, make sense countywide. So you'll see provisions like that. We could talk again about all of those. But again, we can amend the charter. If you go to the next slide there, Heather, through citizen petition, 3 ways, through citizen petition, and we could talk about that. Looking at that provision, I can't see that language, but basically, I can tell you what it says. It says that citizens through the petition process, if they gain 10% of the number, what represents the number of the voters qualified to vote in the last election, 10% of the voters essentially sign a petition, so long as that number also equals 10% in each district. So it's a pretty high threshold. Then citizens can advance a charter amendment. Again, that hasn't happened yet. And I'll talk about the last group like you all that met said, hey, we think we ought to lower that standard. They tried to lower that standard and it went to the ballot and failed. It was the only one that failed, interestingly enough, with no opposition, no anything. It was one of those things that I don't know why, but it happened to fail. The Board of County Commissioners could also put an amendment on the charter on the ballot for local referendum for citizens to consider. Our board has not done that to date, and also lastly through the Charter Review Committee process. Heather, can you back up one sec? One more. I'm sorry, that one. I just wanted to mention too, because it may be something that you all are thinking. So why do counties become charter counties, or what are really the precipitating events that might lead to a county becoming a charter county and that sort of thing? As you look at those. And I can tell you, and Herb can talk a lot about this, it's different in every county. And while, I mean, I started talking about this as a policy analyst like Heather in the early 1990s, and to anybody who would listen to me and say, hey, why are we not doing this? I mean, this makes a lot of sense, and why would we not, and we could do this and we could do that. And for the most part, the response was, well, you know, it's not broken, you know what I mean, that sort of thing. Well, why? What's the urgency behind it? And what we found over the years is that event is not the same in every county, and it's quite interesting because it could be that under Florida law, for example, you can't recall a county commissioner. I'm just using a kind of an example that is illuminating, I think, to everybody. But in cities, you can. Through city charters, they generally have recall provisions. Now, there is the ability for the governor to remove a county commissioner, or the Senate president, I think, suspends, and the governor does it. So there's a whole process there, but there's not for county commissioners in county government, and unless you're governed by a charter county. So in some county somewhere, that might be the precipitating event. That might be the one where they say, you know what, we're going to deal with this issue. We're going to have a charter, and we're going to have a citizen recall. That might be the event. And I think it has been before in a county. But it might be something completely different. And you never know what it's going to be, because as you all know, what happens too is through state statutes over the years, the law starts distinguishing between charter and non-charter counties and through different judicial rulings and other things. And so you might have an event that says, hey, well, as a charter county, we can do this, but we can't do this as a non-charter county, and that sort of thing. I can tell you the event, just for you all, that resonated here. And it's got some relevance today. It was the CRA. It was the downtown CRA. And at the time, and again, I didn't have many people who were really very interested at all in the concept of charter county government at the time. And then the CRA, the idea of the CRA rolled around, and it was one of those issues that in the background it said the city of Tallahassee can establish a CRA downtown. They can unilaterally take ad valorem taxes off the tax rolls for the county and reinvest it back in the CRA. I'm kind of an urban redevelopment guy. I sort of makes sense to me, but what I don't like is the ability for anybody to do that unilaterally, right? And so at the time, the city had the opportunity, and really the right, as a non-charter county, to make that decision unilaterally and take what I remember was $110 million over 20 years. And remember Kim? Kim was involved in our first charter. That's right. Now that I just remember that. But that was the light bulb moment for the county commission at the time. They said, well, wait. So as a non-charter county, they can unilaterally, but as a charter county, they can't. And the answer was, that's right. And so again, the issues are different for counties everywhere to get there. And it's generally, not I don't want to say it's not just a sort of a good government thing, but there's generally a triggering event, and it's different everywhere. So, Heather, could you just go, this kind of, I'm getting to where we're wrapping it up here, folks. Again, 3 ways to do it. So the last time, folks, that a group like you convened was in 2009, because it's every 8 years. And at that time, they proposed to the county commission 7 charter amendments. And you'll see them there, and you'll see 5 of them reflected in our current charter. Because one of them, the board didn't accept, just one. So that's a side note to you all, too. Be real careful which one she proposed, because this board is very inclined to say, okay, the committee wanted to do them, let's go with them. They didn't accept one of them. One of them was that that charter amendments actually that are being proposed by this committee shouldn't even go back to the board. They should just go right to the ballot. The board pumped the brakes on it and said, now we want to see it. You know what I mean? So let's do that. And so they didn't accept that one. The other one was the citizen petition thresholds that I mentioned. That went to the ballot with the other 5 and just didn't pass. The rest of the 5 passed. And you'll see there, and again, like everything else I've talked about today, we can dive into any one of those different things. What do they mean? Why are they there? Why did the committee suggest them? But one, for example, just the next one up is campaign contributions. At the time, the state limit was $500. This committee felt like it should be $200. There are donors in this room who feel like it should be $50, right, Kim? You know what I mean? So you can decide, again, what the campaign contribution limitations could be. Others might say, you should just reflect state law. So, but again, that's very much a decision that you all can advance as they did in 2009. And say that's something that we'd like to recommend to the voters. Again, in 2009, they said state law says 500. Consequently, it's been raised, but at the time it said 500. Let's make it 250. Let's cut it in half. And the voters approved that, so now it's in our charter. Moving right along, Heather. So what's your charge? Again, as I mentioned, your charge is to review the charter and propose any amendments or revisions for consideration by the board, which you deem advisable for placement on the general election ballot. As I mentioned, be careful. They're probably going if you recommend them. Heather, what else do we have here? Okay. Well, let me pause before we go to Herb and just ask you all if you have any questions on anything. And it's okay. I know it's a lot. I just dumped a couple of 100 years of stuff on you. But again, we've got a long process, and we can break these down in little bite-sized pieces and talk about them individually and go wherever you all want to go as a committee. Gordon?
Vince, I have a short one. It really goes more to your professor role. When you look at that map, there are several counties now to the west of us that would exceed 200,000. So it's interesting that Wakulla, being a small one, doing home charter, but you got no such dot on Bay County, Escambia County, Alton County, Oakland. All of them would be at that threshold. I just didn't know if you had, from your professor hat, some reason that the west part of our state wasn't following suit.
Well, it's just it's just sort of interesting. Perhaps they haven't in those counties dealt with some of the triggering events, maybe where they said, "Hey, do we really need to do this?" Perhaps they feel like. And I can tell you, I've gone and done presentations in those counties where the county commission said, hey, we're thinking about this. In fact, I did one a couple years ago in Santa Rosa County, and it was funny because my friend was the county administrator over there, or Okaloosa, one of the two, and they said, we don't want to hear from our county administrator. We want you to come over and talk. Well, he's biased. He's going to try to figure out what he... So I went over there, and I was biased for him. But anyway, but they may feel like it's just sort of working. All counties have different cultural traits too. In some places they feel, the constitutional officers may be really strong, and they may feel like, and we've got great working relationships with our constitutional officers, and at the end our constitutional officers fully supported us going to a charter, but we have a section in our charter that says preservation of constitutional officers, which basically says we shall preserve their elected status and their roles. But there is initially a fear, and the reason I raise that is because it's not inconsequential, because whether you have a strong sheriff or another constitutional officer, they may say, hey, we don't want this, here. We want you kind of, fooling around with that. I remember, my good friend, the late Larry Campbell, who he and I would go to community before he got on board with the charter. In early days, we would go and talk to a Rotary Club or a Kiwanis or something, and he was really a dear friend. But he used to say, I used to say, it's not fair to debate you in any of these situations because I have to be the pointy-headed bureaucrat, and you get to be the tough law enforcement guy. And he used to say, the difference between Vince and I is I like I like the Constitution. You know what I mean? So it was like one of those arguments that you know, I believe in the Constitution. I'd say, wait a minute, what am I doing here? Yeah.
Wakulla and Leon notwithstanding, do most of the charter counties have a lot of municipalities? Is that a factor?
It doesn't tend to be a factor because you have some that are charters that really just have. You have some that have a lot of small ones, but really they just have one big one. You know what I mean? I think about Charlotte County. Charlotte County really just has Punahou. You know what I mean? And they're one of the smallest charter counties. But that issue doesn't tend so much to be factored. It certainly helps when you're Palm Beach County and have 38 municipalities, especially to start dealing with some of these county-wide ordinances and that sort of thing, starts to make a heck of a lot of sense. And you probably have way more trigger points to make you push you over that charter edge than others, perhaps.
In your additional materials, there's actually a comparison of all 20 charter counties. So you can see how many cities, what's their population, what's their government structure. So that's in your binder under the additional information tab, the very first page.
Homestead exemption, is there any difference between a charter county and?
Nope, you still have to follow state law, and just again, there's no distinction there. Again, and you can't be in conflict with general or state law. But where state law again is silent on issues, you are presumed powerful to enact local law. So long as you're not in conflict with the state law, which includes the Constitution, state statutes, and special law.
MSBUs are the same. Are possible in any county,
yes,
as long as you don't conflict with.
Yes. The only difference would be there, and again, this is where you start getting into the nitty-gritty, and this is where, again, there'll be lots of places, as I mentioned, where Herb's the real expert. There's a section that you'll see in the charter that says municipal powers, and it says Leon County shall have all those municipal powers granted in state law to a municipality, to a city. What that means, Kim, is that a county can enact any tax, essentially, that is authorized to a city. And so that's really the only distinction. And I'll give you the real example of that is the public service tax and some other taxes. Before they started aggregating all of those, there were some distinctions between, well, a city can do this, but a county can do that. And still, the taxes and revenues are very restricted. They're very, there are not many of them. We don't have many tools in the toolbox there. You know, there's just a couple, as you all know. But all that says is that charter counties are authorized to levy any tax or any revenue that a city can. So that basically says that even if it's not authorized in statute for you to levy a fee for this, development permit, you can do it. If a city can do it, you can do it. It's sort of a shortcut. Yeah. And it just reflects the fact that it recognizes that those counties are probably doing things that cities are doing. They're doing things like they're doing libraries. Again, you guys will find this, fascinating to some extent that counties everywhere do much different things. There are counties who don't do libraries, or counties who don't do EMS, or counties who don't do fire. You may come from a small county like me, where I went to high school and we had a volunteer fire department. You know what I mean? That's how you had fire. You didn't do. So again, they sort of recognize that municipal power provision sort of recognizes that, hey, these are more like cities because they do all of these different things. And so that's where you get that from.
Vince, what actions would require the filing of a local bill?
Yeah, good. In this case, obviously, you don't need a local bill. This goes directly to the board. Once they receive your recommendations, the board places it in the statutory formula that's prescribed to place it on the ballot. So this doesn't require a local bill, but in order just to have a local bill for something else, I know, for example, I don't want to go down this road with you guys, but I know consolidation is very much a topic out there in the community. That, on the other hand, does require a local bill. And so it's really just a matter of going to the local legislative delegation and having them file a local bill, which obviously is only in effect locally, but requires a full vote of the legislature to be effective. So again, it's really just a matter of the local delegation agreeing to do it, holding their prescribed public hearings, going through their process. But that's the short version.
So let's talk about consolidation.
Yeah, sure.
So is that something that this body would have to address?
No, well, first of all, as I mentioned, you don't have to address anything. But if this body wanted to address that, it's nothing that could be effectuated through a county charter.
Okay.
So consolidation is nothing that could be effectuated. It's a separate process.
Okay.
The reason it gets a little fuzzy too is because it's actually called a consolidation charter too. So the language is similar, but it's a different statute provided under different law. Herb, you want to chime in?
No.
I don't want to get into the issue. It's just
that's all right. It was going to come up eventually.
The specter is hanging out there. We all know it. It's just, how is it going to affect this body? Are we going to get involved in that? I guess it would depend upon whether we as a body elect to take that on.
Well, and it would be sort of a side issue, but you always could. There's nothing that prevents you from making a recommendation that deals with a side issue and not directly with the charter. You could always say, hey, we think it's a good idea, you guys, in addition to what we did here with your charter, we think you ought to look at that. It's always something that you could do, but Herb?
It's exactly that. We could not, the county government, effectuate consolidation unilaterally. That requires a local bill. Except for Miami-Dade and Duval and one other county whose consolidated government occurred in the Florida Constitution, it would require a local bill, and it's been, since I've been here, at least twice on the ballot and failed. So it would require the local delegate. I mean, the rules of the legislature are they don't take up local bills unless the local delegation agrees to promote it. There are other things. That's one way. And again, we can't effectuate that, not with this committee, not with the Board of County Commissioners. There's another way to address partial consolidation, if you want to call it that, which is transfer of powers. And that's another way. Both of those, by the way, require a matter to go on the ballot for the voters to vote. It depends on the local bill, how they set up the voting. I have seen a consolidation ballot where it was one unified vote. In other words, it was a simple majority of all of the voters in the county versus the split ballot, which is like for involuntary annexations. It requires an affirmative vote of the people to be annexed and an affirmative vote of those who are annexing, so inside the city of Tallahassee and the property. In this instance, the transfer of powers, generally it requires the affirmance of both governments to do that, and then subject to a referendum. But again, we can't do that unilaterally. It would require the city of Tallahassee to participate.
Right, thank you.
So that means that this committee couldn't even recommend to the county that go on the ballot.
Correct, but you could theoretically recommend to the county that be pursued in that format.
What about an advisory or something where people could express a preference via the vote process, where maybe what we turn out is not binding, but it's on the ballot up there for the upcoming election?
Folks around the state have put straw ballots on before. That's a doable.
Without charter amendment.
Without a charter amendment, yes.
Something you can remember. We want to limit you guys. I mean, you guys are community leaders. You're interested in this stuff. You guys can chew on anything that you want, talk about anything you want, and ultimately, when it comes down to things like this, we'll just tell you, hey, it could be effectuated through the charter, or this or that, or something completely different. It might be something you just want to recommend and say, hey, while we're at it, we'd also like you to recommend putting a straw poll on the general election ballot. And of course, we transmit that as well.
Another quick question. In a joint interplay, the CRA that the county's recently pulled out of.
But we're trying.
Or you're trying, right? And so if we were to, for example, let's just say if the county ever did something like that, the county has to own the improvement. It's got to be for the people, blight, whatever. needs to be bid out publicly, no private, that sort of thing. How does that interplay with what the city's doing?
Great question. I mean, and it is a little bit of a technicality. And I would tell you, as a charter county, because we're a charter county now, this issue would not be an issue because the county has to give their, in the form of a resolution, give their municipal powers to the city to enact, to exercise their powers of a CRA. So right now, we would have to do that. The loophole, if you will, that we have going on with the downtown CRA is downtown was put in place prior to us becoming a charter. So they're saying you have that ability with Frenchtown and with South Monroe CRAs, but you don't have it because our downtown predates your charter. So that's kind of the catch there, and that requires you, therefore, for us to agree on the terms of your separation.
Southside Frenchtown predates the charter. Downtown follows after the charter. Downtown was 04.
That's right.
Charter's 02. Frenchtown Southside was 2000. If I remember correctly.
That's right. That's right. Oh, yeah. Oh, that's right. Thank you, Kim. And that was it because that was the loophole. Yes, because the CRAs were established prior to your charter. You all don't have that power. The loophole being, and thank you for that, had they established downtown after our charter, which they did, as a new CRA, it would have required, thanks for the clarification, it would have required all of our expressed authority for the city to exercise those powers in the CRA. But they said this isn't a new CRA, this is a boundary adjustment. Wink, wink. And that's the way they established the downtown CRA. They said it's a boundary adjustment. It's bigger than the Frenchtown CRA and has 10 times the value, but it's a boundary adjustment. And so we said, okay, but we didn't say okay. We had nothing to say unless we were going to challenge it legally and all that sort of thing. But that was the loophole they said there was, we're not establishing a new CRA. If we were, if downtown was a new CRA, then you guys would have all the say-so in terms of whether we could do it or not, who sits on the board, what the millage rates are, everything. But since we're not establishing a new CRA, wink, we're only doing a boundary adjustment to the original CRA that was in place prior to becoming a charter county. We exercise that authority. We have interlocal agreements, therefore, that say how you extinguish a district or how you do different things, which we have to negotiate through our interlocal agreements.
So could we do something prospectively moving forward, saying anything in the future we put before the voters, it would need to meet these criteria and have a public benefit and a public ownership and the people would own it, and you're not talking about something slid to somebody on a non-bid situation.
And this might be where Herb jumps in, but essentially I think we might assert those rights today, even without anything new. And I think Herb would probably make the case that it would be a new CRA unless we negotiated something different. But Herb, you want to chime in?
Well, we sort of took that position, and that begat the interlocal. I mean, we sort of forced the interlocal agreement upon the city back then. That got us 4 seats at the table. They were not willing to give us equal, but otherwise, we would not have even had a participation on the CRA. So we used that as leverage, if you would, to gain seats on the CRA, restrict how some of the funding could be done. And so, yeah, that's interestingly, while we're talking about this, the CRA is actually meeting at City Hall talking about the exact same thing. So I think you will see in the not too distant future proposals to amend the interlocal again.
Now, there was an interim space between when you had no representation on the county commission and when you had 2 seats that were ex officio before you had 4
yes.
county commissioners.
We worked our way in.
Right,
so,
right.
Yes.
Because I sat on one of those 2 seats about a year.
But Gordon's right. I mean, and this is kind of the fun stuff in this committee, though. But I think, and let's just have fun here for a minute, I think, again, we still have to follow state statutes, obviously, and there's this very explicit state statute Chapter 165, I think, on the establishment of CRAs, or 63, one of the two, but they say, which prescribes everything that you've got to do to establish one, because I hear where you're going. And it says you need the finding of necessity and the slum and blight and all of it. Now, we all know, anybody that's paying attention to it, know that there are giant loopholes. You can drive trucks through it, and people have in the past, and communities have. They've taken vacant property and said it's slum and blighted on the beach in Florida and said we want to establish a CRA, and it's past the finding of necessity, the planning study, to make those determinations. But just, again, to have fun, Herb, to Gordon's question, could you go above and beyond state law in the county charter to say that, understanding that in Leon County through the charter, not only do you have to do a finding of necessity to establish a new CRA, you have to meet even a higher threshold.
I'd be willing to do that because you know me, I'm willing to go out there on that. I think the city would argue that those rules of CRAs are preempted to the state, and so we'll have to.
You put it up there, we'd at least bring it up for discussion, and if you put it on the ballot, it brings it to a whole nother level of discussion, right?
But session convenes in January and February, so by the time this body completes its work, they may already have preempted that issue.
Well, it's just one of those hot topics. So I was.
What is a stress that the county has today in operating county government that the charter doesn't address but could? Something that is a big factor either in the type of development we do, or where we put it, or the way you run government.
I'm not sure I would call it a stress, but we chose when we did the 2002 charter to not do municipal preemption. We subsequently amended on the environmental thing, but some county charters, Broward is one, completely preempted to the county all regulation of guns and firearms back in the day before the legislature said you can't do that anymore. So there was
the city doing it for the county, giving the county, or taking away from the county?
County charter said if we adopt an ordinance, it prevails over any ordinances of any city within Broward County, and therefore you have to register your handguns, and it had a 3-day waiting period, and the courts upheld that, saying, no, you're a charter county and you can do that. Broward, I think also, and Palm Beach has one too, Broward has another provision, again, they did not restrict themselves in their charter, that made their land use comprehensive plan prevail over all of those cities' land use plans, and that got litigated, and again the counties prevailed. Dade, which is its own country, and Broward and Palm Beach also have provisions that impose their I'll say ethics code, but they have an inspector general established by charter and said it applies to you, the municipalities, all 38 of you. Oh, and by the way, here's another surprise. You all have to pay your proportionate share of the cost of that office, litigated, and the county prevailed. But we would have to change our charter to say that in the instance of conflict between the city of Tallahassee, because there is only one city, and the county, over those sorts of enactments, the county's ordinance would prevail. We chose not to pursue that in 2002. Obviously, the city would fight hard against that, but that could be done.
Going back to Herb's thing, obviously, on the gun issue, the state then came back and entirely preempted local government, so that's no longer an issue. But to Kim's issue, Kim, I don't know if there's really, first of all, I just tell you this, the city and the county on a day-to-day basis, operationally and that sort of thing, really work very, very well together. There really aren't any sticky issues for us, either relative to that issue or that we deal with on a daily basis as a county organization that boy, if we just had that fixed in the charter, or else we would tell you, or else the board probably would have told you and said, hey, really look at this. But we recognize that there are always improvements. There are always things that the city, for example, we made our county commissioners nonpartisan here in Leon County. That was something that came from the last group of citizens that were convened and said, well, we can't. We have that authority now under the county charter that if we decided to do that, we could, again, with the campaign limitations as another example. But really, we would tell you if there were one of those things we were just running up against problems structurally or something that could be fixed, we'd be the first to throw it on this table and say, hey, help us. But through this process, again, you all will get to deliberate any ideas which you're here, which you feel might be an improvement that fall into any of these areas.
Might there not be problems that you're dealing with that could be resolved by the charter, but other directions that the county is interested in pursuing? It's a slightly different take on Kim's question. Is there not per se that there's a huge problem that you see needs to be addressed, but are there other directions that the county might be interested in going that we might be hearing about it at future meetings in terms of issues to consider for the charter?
I don't think so, no.
Okay. I didn't know if there was a short list.
Despite what you may see on the news or read in the newspaper, the staffs of the city and county get along great. I mean, we have multiple interlocal agreements that provide for services that we've negotiated, and both parties came away happy. And, it's not one of those, well, it's not a good deal unless both people go away unhappy. No, I think we both came away happy on those.
Just to clarify, and I'm not saying an issue of contention between the county and the city, but maybe, Vince, from your perspective as an administrator, it might be helpful for more efficient government if we would consider the following. Didn't know if you had any of those types of issues you were considering.
One of the things that was brought forward from citizens reviewing lots of different charters last time around was, and I think goes, Neil, to some of the sort of the internal stuff, and it was really just sort of a good government thing, is a non-interference clause. We weren't experiencing a problem, and what a non-interference clause is just simply says in a council manager form of government, the county administrator runs the day-to-day things, hires people through meritorious things, procures, purchasing through, purchasing, and that the day-to-day decision-making relative to the now, and it says, for the purposes of inquiry and asking questions, that sort of thing, county commissioners, can ask that, but they can't direct staff. They can't direct staff individually. Now that's been a problem in other places. It wasn't a problem here, but it was also one of those things that people said, well, we can do it. Let's just make it real clear that that's the way it works. We always had a real strong council manager form of government. Again, it wasn't a problem, but the citizens last time around said, hey, we want to make sure, the people change. You won't always be here. They won't always be here. Let's make sure that those lines are very clearly delineated in the charter, so that passed.
Thank you.
What about the districts? We got 5 districts and 2 at-large commissioners, so none of us can vote for the majority of the commissioners as a citizen of Leon County. Is that something that this group would take up?
The short answer, and Herb can jump in, the short answer is you can effectuate that through a charter, a districting scheme. Now, the complicated answer is, Herb, you might as well deal with it now.
We are still, after 30 years, or 28 years, something, from the middle of 1980s, we were, the county before my time and Vince's time, we were sued by the NAACP, and the chapter president at the time was then subsequently Commissioner Anita Davis. In the course of that, again, I'm reading, you can only get so much by reading what's in the documents, but we stipulated with the Justice Department to the setup that you see now. 5 districts, one of which has to be a minority majority district, one of which has to be a minority access district, and the 5-2 was what was established. A court order from the Northern District Federal Court was entered saying that's what you, Leon County, need to effectuate, and we did. there were some interesting plays on that, one of which is this dais behind you was built for 5 commissioners and the administrator and the attorney. When we went to 7 commissioners, the administrator and the attorney went to those desks because there was no room on the dais for those offices, and it stayed that way for a long period of time. So we're required to make sure that we comply with the federal court order every time we try to do an adjustment. So you are required to do an adjustment of your single member districts at each census. And so we've done that, but we make sure that we've comply with that. We talk to the plaintiffs and their lawyers that are still around and get them to hopefully agree, and we have the last 2 times we've gone through a census. So the answer is yes, you can do that in your charter, but we're still under court order. The federal court reserved jurisdiction over us to make sure we were continuing to implement that. And so it would require both a recommendation to do a charter, but it would also require the county commission to direct me to seek an amendment to the court order, or perhaps dissolve the court order, the jurisdiction, and who knows what the federal judge would do, and who knows what the NAACP would do if I made such a request.
Have you ever looked to see if you could, with 4 districts, meet the requirements of the court order?
The answer is not in great detail, but the answer is yeah, it still could be done.
And but for the court orders and that process that Herb said, yeah, in other counties, in other charter counties, that's the type of thing that can be effectuated through.
You could, for example, eliminate the 2 at-large commissioners and just stick with the 5.
Yeah, exactly.
But if you file a petition with the federal court to do away or to take away those restrictions, then you wouldn't have to have any requirements on your districts, correct?
That's true. That's right. I mean,
So
you
is it
still
just-
need to meet the 1964 Voter Rights Act in the manner by which you elect officials. For example, back during this time period and in the 70s, in fact, while I was the city attorney in Delray Beach, we elected our 5 city commissioners by the top 2 or 3, depending upon how many seats were open. That's who won the election. So if you had 9 people running for the 3 open seats, the top 3 vote getters became the new city commissioners. That's a clear violation of the Voter Rights Act, because it denies generally the representation that it requires. And so how do you do that? Well, the city of Tallahassee, and ultimately on my recommendation to the city of Delray Beach, was you can't do that anymore. You need to make the elections fair, and so they went to numbered seating. So you ran for it, a seat, not a composite, if you would, and that complies. But we here did not do that, again, before my time, and ultimately got sued by the NAACP and the Justice Department, saying that our method of elections was a violation of the federal law, which, candidly, it was. I mean, we didn't stipulate that it was, but it was, and so that begat this 5-2 arrangement, for good or bad. But we're still under that court order, and I would not do anything to violate the court order. So we'd have to address it. If you all recommended doing that, then we'd have to address that in some fashion. And I'm not saying what the Justice Department might agree to, or the NAACP might agree to, and I don't know whether obviously the composition of those 2 bodies is way different than it was in the 1980s and 70s. So,
but it sounds like in the order there were only 2 required districts.
Only 2 required districts, but the setup of 5-2 was also part of that order.
But is it clear that the 5-2 decision was part of the 2 districts decision? I mean, in other words, was it to remedy something that in some way, or was it just the way the numbers came out?
As I understand it from, again, reading the material, the 5 single-member districts was what the Justice Department wanted. And I believe Leon County said, oh, but we'd also like to have 2 at-large. There was a lot of negotiation, I guess is the right term. But ultimately, the court said, no, that was not a violation of the federal law to have the 2 as long as you had the 5 and that it met those 2 criteria. So, yeah.
This is a good discussion, exactly the kind of discussion that we want to have at this table. But let me do one thing, if I could just offer this from a facilitation standpoint. We're going to tell you today, once we get through a couple of these presentations, the Herb's presentation on Sunshine Law, then Heather is going to walk us through how you guys deliberate certain issues. For example, at your next meeting, I think is when we start, and I think we'll tell you today, hey, come to the next one, is that right? Ready to kind of talk about your ideas and put those on the table. And there'll be a process that Heather will walk through, and they'll say, hey, look, if this is an idea that has 4 people, 4 among you, that are interested in really pursuing it, then we agenda it with analysis, and you guys will basically get the agenda and analysis. You'll be able to discuss all that. Then there'll be another threshold, voting threshold, if you guys want to move it even further. Then there'll be another one if you want to go to public hearing. There'll be another one to recommend to the board. So we're going to go over that in just a minute. That might help you guys kind of wrap your brains around how you want to discuss some of the issues.
Back to the conversation we were having before about what the county's position, what we might need to do in the charter. Would it be a fair summary of what you said? Although the process is open for us to consider any good ideas we come up with, the county doesn't, in fact, think we need to do anything.
Well, no, I think we think that we need to do this process.
No, I know the process, but there's no specific things we need to accomplish in the charter so that if we didn't make any amendments, the charter would be open.
I think that's accurate. Yeah, I think that's accurate. And we do that deliberately in terms of we bring an item to the board, Ken, it says just that. We say, we throw all the issues on the table to the commission and say, hey, look, these are our previous proposed amendments that have gone through the citizen process. Here are other ideas. Commissioners, do you think there's anything, we're about ready to convene this process? And again, they might have been able to come up with, if they wanted to, they could have said, well, we want them to look at this. Again, they made a decision to not do that. Maybe they didn't want it to seem like that was the exhaustive list or that that was a specific charge, but instead they chose to say, hey, it's wide open for you all to discuss anything. But I think, Ken, you're right. I think and like we said earlier to Kim and Niels and Michaels, if there were really pressing issues that we were dealing with, we would definitely get them in front of you and utilize this process for that.
And I think that lays at our feet what this really is a unique process. There's not a problem or issue driving us being here to try to solve, which makes it really unusual, I think, for a group to get together like this on a 7-year basis and review something.
You just step back, look under the hood, and take a long view and see how it's working. And that's the way these processes generally go. So, if it's I know you had something. I don't want to.
No, I'll wait till the next meeting because the question continues on with the redistricting issues.
Herb, I think you're on. Okay. Vince did forget to tell you the most important thing in our county charter, though. I think it was just oversight, not intentional, which is in the Florida statutes and in the Florida Constitution, the office of the county attorney doesn't exist. A county administrator's office exists under Chapter 125, but not the county attorney. So the county charter establishes the office of the county attorney, and here I am. So that I like that part of when we adopted the charter. No one has ever contested that non-charter counties can't have a lawyer, but it's a whole lot better to be able to say, no, look, I'm in the charter right here. So,
which means they can do away with it, right?
Right. Well, you can dissolve that. There have been a couple of counties, by the way, that have had non-charter counties that have had a problem with who do you report to. And that's solved. It wasn't a problem again here when we adopted the charter, but there are some places where the county attorney reports to the mayor only. It used to be called chairman, but now some places call mayor and or the county administrator. That the legal department is a division of the county administration, but not here. All right, so Vince got to have all of the fun stuff I have to have now. I have to be the wet blanket here and talk to you about the boring stuff. For those of you who have never been involved in public entities and been a part of public entities, and I think Ms. Hinkle and Mr. Ellis are probably have some of this in their respective former or current jobs, you are now almost the same as a county commissioner as far as the rules apply to you. You are what the courts have called a decision-making body, which is different than a fact-finding entity. So therefore, these things apply to you that you may or may not have ever had to deal with, and they're a little odd. I enjoy talking to new county commissioners. I do a presentation at the FACT conferences a couple of 2-3 times a year. The most fun are with new county commissioners because they give me the deer in the headlights look when I tell them they have to do these things. They generally are going to apply to you. So walking through the slides, as a decision-making entity, the Sunshine Law 286.011 applies to you. That requires that all of our meetings be open to the public. It requires that notice be done in advance, and it requires that minutes be kept. That's all the Sunshine Law really requires. But what it also prohibits is a meeting from occurring without those things taking place: notice, opportunity to attend, minutes being kept. So what's a meeting? It's any two or more members of the same decision-making body who are talking about substantive matters that may come before your board. So there's nothing wrong with Mr. Perkins and Mr. Thames having lunch together. That's not prohibited. But you're not supposed to, and you're not allowed to, talk about matters that are coming before this entity.
Unless, of course, you have a lot more seats there at your table at lunch, and you're willing to provide for a lot. You're willing to pick up a much bigger tent.
Right.
And you've noticed the meeting and somebody's taking minutes.
There's a lot of litigation. That probably the biggest amount of litigation over local governments is Sunshine Law and public records. And there's an interesting bill that's been pre-filed to overcome a case out of Seminole County called Finch versus Seminole County, in which the 5 county commissioners went on a bus tour of available properties, did not speak to each other, had a member of the press present, no exchanges of any dialogue whatsoever. They just listened to what amounts to a tour guide. Court found that to be a Sunshine Law violation, even though they had no discussions between them. There's a pre-filed bill right now that would make those an exemption from the applicability. So what does that mean? You really, the practical standpoint is wait till you get to your next Thursday meeting if you want to debate or discuss a matter about the charter. And it's for you. You're not on another body. That makes my commissioners and the city commissioners crazy because they're not allowed to talk about. City commissioner, county commissioner can talk about anything between the two of them. But not things that are blueprint, not things that are CRA, not things on where there are CRTPA, that's our transportation thing. So though they're not supposed to talk about those things. So here you only have a topic in a committee. So if you bump into each other on the street, say hello, say how's the family, and say, boy, I hope you support my position that we should extinguish the county attorney in the charter. Okay, that last one, no. Okay, Heather, I'm ready to punt onto public record stuff. There we go. Thank you. Public records also applies to you. So if you receive information in a written form about your activities as a member of the Charter Review Committee, that's going to be a public record. You'll need to retain it. My suggestion from a practical standpoint is if you get a letter or an email or a memo from a citizen saying, I want you to sponsor this amendment to the charter for me, that's going to be a public record. Get it to Heather so we can all have it and it's kept a part of the record. I would also suggest, and without current events notwithstanding, don't text people. Okay, don't encourage them to text you. It's very, very difficult to keep those.
No Twitter.
Don't do Twitter. I mean, I don't do any of those things, but that's because I'm old.
How you do that.
No Facebooking or Facebooking each other. That kind of stuff. They're all going to be public records.
How about selfies?
Selfies are good. That's okay because there's no exchange at that point. So if you get something from somebody outside our circle of 14 members, then that's about what we're doing, then it's a public record and we just need to retain it and disclose it if somebody asks for it. And from time to time, I suspect that one of the local journalists will make a request to say, have you gotten anything from outside interests? And we'll say, yeah, here's the 2 memos that we got. So
maybe you're not young enough to know how to do this, but if you get a text from somebody, you could copy that text and send it to Heather in an email.
Yes, I mean, and that's what you have to do if you get a text of that variety. I'm just.
Doesn't even know how to text.
Well, I know. my kids can text each other on their phone in their pocket without looking. I can barely do that on my desktop. So, that's the deal with the public records law. It applies to you, and we need to just make sure that we keep those things which are public records and using your point person. Things that are not public records, I can't imagine that you would do that, but it's possible that you could text Mr. Thomas here and say, hey, what are you doing for lunch tomorrow? Okay, that's not a public record at that stage. That's personal and is exempt from public records, or it actually isn't a public record. But the best thing would be if you get something, and by the way, if you get it on your personal phone or your phone that is issued by your employer, or you get it on your desktop at home on your home computer, doesn't make any difference. It's still a public record if it pertains to what we're working on. Next, what do we have as a slide here?
You want to skip on?
Yeah. Because I've talked too much already anyhow.
No, you're not going in order.
I noticed that. That's what will make it much, much better for the quiz when I make them put their books under the desk later. So, by the way, you will also get the minutes from each of these meetings and we'll keep copies of that so you don't need to worry about it. And by the way, all of the stuff that you have here are public records, but you don't need to personally worry about that because we have a set that if anybody asks that, okay, what was in the binder? We have a set, so.
But Sean, he might want those criminal penalties back up there. I know how Herb is. He likes to have fun with those.
Yeah, this is such an august group. I'm not really sure that we need to warn you that it's also a misdemeanor if you don't do what I just suggested that you don't do. You're also subject to Chapter 112, which is the statewide code of ethics. Parts of it will not apply to you because you're not an elected official. You're an appointed official. But some things will, both from a standpoint of pure ethics and also by the manner by which you conduct your business. So, for example, Chapter 112, which is where the state ethics code resides, you don't need to worry about nepotism because you're not going to hire or fire anybody or supervise your next of kin, so that I'm not worried about that. You're not going to need to worry about doing business with your own agency because we've already taken care of waiving whatever conflicts when you got appointed, so that's done. But the two big things that I think you should just be aware of, and that is that you are going to potentially have a voting conflict. Now, I tried to play in my mind with how that would occur with your respective backgrounds, and I couldn't come up with anything that you would have a voting conflict on. But it's possible, and in that case, my best advice is to give me a call and say, hey, do I have a conflict? And if so, then we will go through the procedures of how you have to disclose that, not vote, file a voting conflict form. But I'm not really able to come up with something that is going to be, and if you look on the slide, which would inure to the special private gain or loss for yourself or any principal or entity by whom you are retained.
Well, you could, Herb, have fun with Kathy. I mean, there could be. Yeah. There could be an issue there, but again, it'd be a stretch, and there'd be a process to deal with it. So, but voting conflict applies, and you may or may not watch our commission meetings, but a conflict of interest comes up here for the county commissioners who have businesses, who are voting on zoning things, voting on contracts. You know how often it comes up? About twice a year. And that's with their positions, so the chances of something coming up here are pretty small. Yes.
But Herb, absent a conflict of interest, each of us is required to vote on every issue that comes before the group. Yes.
You're required to, under the Florida law, you're required to vote unless you have a conflict of interest. So there's no abstentions. I'd like to abstain on voting on that because I can't make up my mind. No, you're required to vote. The other thing is, and I know you're going to be in such high demand over the next 120, 180 days, I doubt seriously anybody's going to come to you and offer you a gift. But you're not permitted to take a gift from somebody who's not your relative while you're serving on this board. And that's just the standard. You can take gifts, except from lobbyists, in any amount, but you have to file a financial disclosure form, a gift disclosure form that you do quarterly. As I say to county commissioner, you're not going to come up with any new friends that you didn't already have when you got this position. So I don't think that's going to be an issue, but I have to forewarn you that somebody says, listen, I really want you to sponsor this amendment to the charter, and I want you to advocate for that. And as a thank you, they won't say as a bribe, but as a thank you, I'd like to give you this Waterford Crystal service. And every time you have a sip of wine or you make punch in the bowl, you'll think of me and remember that you're supposed to be advocating eliminating the county attorney from the charter. And so, is that possible? Sure. But I think it's unlikely. Again, if you have a question, please just call me at any time. You can call me at home too, but I mean, just give me a shout and say, hey, I'm about to get this from somebody. It is clearly not an attempt to influence me on the Charter Review Committee. It's because I've known this guy for 50 years. It's way different with the elected officials, but with you all, it has to be essentially a quid pro quo. I'm giving you this because I want you to advocate a position that benefits me. I want you to put in a charter that the county commission is prohibited. I think this is probably a constitutional problem, but I'm just making one up, that the county commission cannot purchase anything from anybody that doesn't have an office in Leon County. That might benefit a particular business or entity. That person would make a lot more money that we only buy toilet paper from the one provider here in town, and we don't buy it off of the state list because that provider is based out of Orlando. So there are those potentials. I doubt it sincerely. But again, if you feel uncomfortable, what I tell the commissioners is, if you feel uncomfortable, don't do it. But if you want to think about it, give me a call and we'll walk through it. We pretty much have a general rule against gifts, but we'll give you a nice proclamation when you're done with your service to the county, and that will be the gift that you keeps on giving, I guess. So I'm just talking about, I mean, you're not allowed to, under that provision, you're not allowed to take, as it says on the slide, misuse your position or take unauthorized compensation, water, Diet Cokes, and some sort of nature bars in the back about all the compensation you all are getting for this.
Can we raise the bar to donuts?
We might be able to do that. So questions about that? I don't think the issues are going to come up like it would in other bodies. I can tell you that 8 years ago, none of those occurred in the other Charter Review Committee because it's just, we're going to be in our own little world sort of here. But at some point, people are going to start showing up here at the lectern requesting that you consider some item, and that person then approaches you and says, I really, really, really want you to promote this. Let me buy you dinner. Then that's where we start to cross over the threshold. So I think that's it, isn't it, on my slides? I always am the big wet blanket in these events, you know, to tell me what I can do, not what I can't do. And I spend a couple hours every few months talking to county commissioners about what they.
That's nice. That's the nicest presentation I've ever seen. Usually, you have mug shots of commissioners in there and everything. I like that.
If you ever want to see them, let me know because I have I collect baseball caps. I have about 300 of them in my house, much to the dismay of my wife. But they go end to end to end, and they don't take up much room, I say. But I also have been collecting local government officials' mug shots for the last 10 years, and I have a fairly significant collection of them, which I trot out from time to time, mostly at the new commissioner orientation presentations that I make. And I tell them about the town of Sweetwater, and I tell them about the mayor there who went to federal prison, and those sorts of things. So,
the town of Sweetwater, which
is founded by Russian circus midgets. Just in case. You could win a beer later on today with that piece of trivia.
Russian circuit midget.
Yes. I have a photo in my collection
in case
of
anybody forgot they were in Florida.
The founding mothers and fathers of that town.
A lot of that going around lately.
Yes.
I was curious, Herb or Vince, from the last iteration of the Charter Review Committee, what was the level of public involvement in that process in terms of the hearings?
That's a good point. It's actually a good transition. Heather, I might let Heather talk a little bit more about this, but I also neglected to say, and she was probably trying to hide this fact too, but it just occurred to me, and I want to share it with you, is that Catherine is the only member that actually served on the last one. So that there's another just little sharing for the group. She was in a different role, a different capacity, but she was on that committee. But it was, we do everything we can to generate interest, and you'll be, this is televised, I should have told you. I'll make sure they get your good side. Whatever that might be.
We do have a makeup artist out back in case you know.
We stream it. Of course, we advertise it heavily. Every agenda that you all have, you'll see it prominently on your agenda. Probably the last item on your agenda. Hearing from the public. And my recollection was that it was pretty good. I mean, there was a general, pretty steady stream at your meetings of people who came out and shared ideas and that sort of thing. My recollection was heavier at the beginning, lighter at the end, but we do everything we can to generate that interest, and you never can quite tell. It just depends on what's out there in the air at the time. But yeah, Catherine, you got anything there you want to add?
No, there was a lot of community participation, but I think there was, amongst the members, there was a lot of agendas on the committee is what I recall. A lot of personal agendas.
What were some of those?
Some of the personal agendas?
Yeah. I remember back, I can't remember what they were.
Let me think. Gosh, it was so long.
Well, one of them was Cliff Dale's $250 campaign contribution.
Yeah, the campaign contributions. There was the public.
Well, we just saw it, I guess. The 6 items that were listed were probably what they were.
I remember some of the commissioners. The commissioners were invited to come and speak if they chose to. Commissioner Proctor did, and he had a few ideas that he wanted.
And you might hear that again.
Yeah, the fairgrounds probably.
And the public utility board that he wanted in the charter.
You do have a final report from the previous committee, which goes over all of the issues that they considered, as well as those that were finally presented to the board as potential charter amendments. So you have that available to you in the back of your binder under that additional information. So you can see everything that the previous committee considered and ultimately adopted to recommend to the board.
Okay. Let me introduce again Heather Peoples again.
Hi.
Your go-to person on this committee. She'll be the staff person. Heather's great. Heather, is there anything that we forgot in terms of our public notices there? Did I cover everything?
No, that's really it. We'll publicly notice everything. The county attorney's office will publish a notice in the newspaper as well. And we make everything accessible online on your charter website, where you can also stream these meetings. And out front, any members of the public that want to see what you're receiving in your meeting materials, there is a copy at the front desk that they can walk up and look through to see what's happening in the meeting packet for each meeting. So all of that is readily accessible to the public throughout this process.
You didn't cover Heather's background, which is she has a brace on her knee because she tore her ACL in the county kickball league.
Did you
score?
That's the story that I'm sticking with. I temporarily thought I was going pro and decided to try and attempt a dive for a pop fly. As you can tell, it didn't work out the way that I was hoping. So throughout this process, I will also be having my ACL surgery. So we'll have some good times together.
Boy.
So as Vince mentioned earlier, the board provided some preliminary bylaws for your review. We're not going to take a formal vote on those today, but this is to simply help assist you throughout this process. You have copies in your binder. It's under that third tab. So we encourage you to read those before your next meeting, where you'll take an actual formal vote on them, in addition to electing your chair and vice chair. So in addition to the bylaws behind them, you'll see all of the referenced statutes that apply to the committee, as well as the board policies. You also have a cheat sheet on Robert's rules for those that are interested in parliamentary procedure. So those are all included in your bylaws. So really the one thing that I want to spend a little bit of time on in your bylaws, you have a green handout in your binder, and that's what we'll be going through, and that's your process for deliberation. It looks like this, but it's green, so that's in your front pocket.
It's your cheat sheet.
It is, it's your cheat sheet.
For you to know in your binder.
Yeah, so just like Schoolhouse Rock, how a bill becomes a law, this is how an idea becomes a charter amendment. So the very first step, which we'll take at your next meeting, where we begin our issues and decisions meetings, is simply coming to the table with your ideas. So you'll have an opportunity to propose ideas to the rest of the committee, to agenda for future meetings where staff will bring back additional information and analysis. So to agenda an idea and take that next step, you need simply 4 votes from the committee. Ideas that don't receive votes won't be considered further. But those that do receive those 4 votes make it on to step 2, where we set an agenda for a future meeting. You'll get that analysis, and the committee can make a decision about whether or not they would like staff to prepare some proposed charter amendment language. So to get that language drafted, that requires a slightly higher voting threshold, but it's just a simple majority of the committee. So the first phase, that issues discussion process, that'll happen until January 11th. And after that, you'll transition into your second phase of meetings.
Kevin, can we go back to the first, just a little conversation? You'll see, guys, everybody, this is really straightforward stuff. I mean, we broke it down into the basic steps here, and as Heather said, the first one is simply, again, and you'll start at your next meeting with the ideas. Anything is on the table. You all will, as she said, elect the chair and a vice chair, and they'll facilitate. You guys can discuss an issue as long as you want. You can beat it up as long as you want, but ultimately to get to that next step, just 4 votes. Again, if it doesn't have a requisite 4 votes, probably not worth spending your time on. And just 4 votes, again, get you to the next step, which just, as we mentioned earlier, just brings it back with more comprehensive analysis on it to say, here are the pros and cons, quick and dirty analysis, nothing, too drawn out, but pros and cons, high-level stuff. Is this what you wanted to look at? Oh, did you want to add to that analysis? Did you want to take away? Did you want us to broaden it or narrow it? And that sort of thing. And just a simple majority vote gets you there.
And feel free to stop me at any point if you have questions along the way about this process. But again, the cheat sheet is a really good tool for explaining what your process is within the bylaws. So once you get your 4 votes, you then get your agenda back, and that's when you make that decision to have staff bring back that proposed charter amendment language. So you'll review the language, and then to advance it to a public hearing to get comment from the public, that again requires a simple majority vote of the committee. The charter requires that the committee hold 3 public hearings. So if you want to advance it, you will have staff schedule your proposed amendment for those 3 public hearings where you will get feedback from our community.
I have a quick question regarding that. I mean, how much does this correspond with public hearings for the board? I know that at board public hearings, there can't be any real language changes that changes the intent of what is being said. So what if at the public hearing somebody does say something that 10 members of this committee agree would be a good fundamental change to the charter language?
Don't have to start over.
Okay, thank you very much.
But it would require 10 votes. So at that point, when you get to public hearing, the voting threshold is increased. So to make an amendment before sending off a proposed, to make an amendment to the amendment, you would need 10 votes before sending it to the Board of County Commissioners. So that slide, let's see, oh, we're there. So public hearings, that'll happen in February. Those 3 public hearings. And at the final one, that's when you would take your vote to either as amended or as presented, provide or propose those charter amendments to the Board of County Commissioners. So once the committee's proposed amendments are provided to the board, our Board of County Commissioners, they'll have a workshop. They'll go over your final report, which staff will prepare for you. Following that, they will also have a public hearing where the public can provide comment. And then they will take a formal vote to adopt the amendment to go to the ballot. And the general election will be held on November 6th of 2018. If the voters adopt the proposed charter amendment, it'll go into effect January 1st the following year. So that's from start to finish how this committee can take any of your ideas, get additional feedback, and go through the process of looking at what an amendment might look like, getting public feedback, all the way to getting it to the ballot to the voters.
So very high level, you'll see it, if it gets that initial 4 votes for you guys to look at it, you'll see it with increasing levels of analysis at least 3 times before you ultimately decide, okay, we want to forward this on to the commission, including your public hearing.
So that sort of ties into your schedule overall, which you all have been provided with. It's in your binders. And the only real difference from the preliminary schedule that you've received initially is that there will not be a meeting during the New Year's holiday. Otherwise, you'll be meeting each Thursday. And we'll be meeting typically during the lunch hour unless it's specified otherwise in your schedule. Public hearings are going to be held at 6 p.m. to allow for additional public participation and feedback. And because we're holding these meetings during the lunch hour, you will have lunch. So no donuts, but lunch will be provided.
And we don't have to report that.
You don't. You will not have to report the lunch. If you have recommendations, though, let me know. So this is your meeting.
Lunchtime, is that noon?
11:30 to 1:30. So that brings us.
Is lunch provided?
Yes, lunch will be provided. So that brings us to your next meeting, and we've kind of covered a lot of the things that will happen during this meeting. First and foremost, you'll take a look at your bylaws again, adopt those, and then immediately following, elect your chair and vice chair. Staff will provide a very brief overview of Leon County government, and then that's when we turn things over to you. That's when you'll come back to the table to propose any ideas that you have to the committee. And again, 4 votes is really all it takes to then schedule or agenda the idea so the staff will bring back some additional analysis and information for you. But that's when that would happen, at that next meeting. So any questions before we
I have a
adjourn?
procedural question.
Sure.
When we get down to step 5, does the county commission reserve the right to hand anything back to this committee, or do they just move it forward at that point?
They can accept it, reject it, or change it. So they can do any of the 3 things and place it on the ballot or not.
Okay.
But there isn't a provision to send it back and have you look at it again.
Okay. Thank you.
Staff would, of course, provide you with any decisions that the board makes. You'll receive updates throughout this process. And by staff, I mean me. I will be sending you updates throughout this process and keeping you in the loop. So once your recommendations go to the board, you'll continue to receive updates on the decisions that they make and where your proposals are in the process up until
I think
the election.
I'm sorry. I think the only distinction there is Michael, that the board has a higher voting threshold. If they change it, then it becomes a board-initiated amendment or change it substantively, and then I think it's just a higher voting threshold or something.
They have to get 5 affirmative votes then.
Wow.
I do have a question. I've noticed that there is a gentleman in the audience. I know that we are not taking public input. I don't know if he can be here at a subsequent meeting, but since he has been here the entire time, I would hate for him to not be heard if he wanted to speak today. So I don't know if he came to speak. Okay. Okay, thank you. I just wanted to make sure.
And as part of your bylaws, you'll have a set of agenda items that you'll have at each meeting, which includes public comment. At every single meeting, there will be an opportunity for the public to participate and provide input. So with that, I really don't have anything else unless there are any comments.
Heather, that brings it on my agenda. That brings us to the end of the agenda, right?
That's it.
Well, committee members, for my part, again, we appreciate it. We're gonna use your time because we value it in the most productive way that we can. And I think you all have a really great committee. We're really looking forward to this process. Heather, cards and validations, anything that they need? Parking?
So those that parked at Clayman, I have validation stickers that I can give you. Those that parked in the public garage at Calhoun and College, you simply need to just mention your name, that you were here for the committee meeting, and they'll validate your parking for you. So if you just want to come up to me after the meeting to get your parking tickets validated, those that parked at Clayman, I can take care of that for you. Committee members, do you have anything else before we adjourn? Anyone? Really, again, thank you very much for doing this. We appreciate it. Thank you.
Thanks.